Welcome to Litigation and Capital.
Hey everyone, welcome back to an all-new episode of Litigation and Capital with Stephen Mirsky. I am your host, Mike Leon. Stephen here is the founder of Mirsky Corporate Advisors, and in each episode of this podcast, he breaks down the high-stakes legal issues affecting companies like yours, those earning between $10 to $100 million a year, so you can turn the complexity into leverage and protect what you've worked hard to build. Today's episode, we're going to be talking about receivable purchase agreements, how they're treated sometimes as loans, and why the difference matters when you're the business owner signing the paper. Stephen, it's good to see you as always. I'm sure a lot of small business owners are interested in learning more about this. When a contract is labeled as I'm going to use air quotes here, like a purchase of future receivables, what are the key facts that the courts look to determine whether it's actually a loan?
Mike, great being here. This is one of my favorite topics. I love this because it's it's a chameleon. It's a shapeshifter, and it depends on which angle you look at. And so let's jump in. So a receivable purchase agreement, or what I call an MCA agreement, merchant cash advance, it's they say it's not a loan. They say, it's a flexible payment term. If your sales go down, we'll modify the payments, whatever. The reality is they're treated like a fixed term. So there's a difference in the industry. There's a difference between what the contract says and how the lender acts. And we'll go into that in a little bit, but I want to state that from the outset. The New York courts analyze a MCA agreement based on three components. One is whether or not there's a fixed repayment term. The second is whether or not there is a meaningful reconciliation mechanism. And third, whether the business going out of business or filing bankruptcy constitutes an event of default, right? And so the drafters of these MCA agreements are smart, and they're saying, "Oh, hey, look, there's a reconciliation provision here. Hey, look, you don't see an event of default that says bankruptcy." And so, Your Honor, this is a purchase, right? Well, let's dive into it a little bit different. What are the components of an MCA agreement? An MCA agreement has a couple of components. One is they purchase future receivables, meaning money that may come in, at a discount. What does that mean? Well, that means, for easy math, I'm going to buy $1 million of your future receivables today, and you'll pay me back $1.5 million. And it's not a loan because I don't know if I'll ever get paid back. All right, sounds reasonable. What's the problem here? The problem is the allocation of risk. Does the person receiving the funds, do they have to pay it back? Absolutely. Or is it does the buyer actually retain the risk that the receivables may never happen? And so what I find in my experience is that the purchaser, or the MCA company, frequently says, "Oh, we assume the risk." But what do they do in reality? Well, if you miss a payment, what happens? If you miss a payment, they're going to send out what's called a 9406 letter. What does that do? That's going to freeze all your incoming receivables. Then what are they going to do? They're going to file a lawsuit against you. And then what are you going to do? You're going to be freaking out as a business owner because you're going to say, "Oh crap, I have no money coming in. And oh darn, they've ruined my reputation. I need this to go away." And so then they get you to sign a settlement agreement that converts it into a fixed loan. And this is what they do. This is the industry. So why do people sign these agreements? Well, I could go to a bank and go through an underwriting process and get rejected, etc. Or I get called by these guys every day and they say, "Hey, look, we'll fund you tomorrow." And they promise you sweet deals under certain terms, and then they bait and switch it. So that's sort of my overview of the industry. And I guess we can get more into the weeds.
Yeah, well, let's get more into the legal weeds of it, because you touched on the MCA contracts and how the payments fluctuate based on receivables. Can you pinpoint, or what have you seen in your experience, how the courts evaluate whether the mechanism is genuine, or is it just like you said, like it's just a fixed fixed payment loan that's kind of dressed up as a sale?
It depends on where you are. Let's move to California real quick, and then we can take a look at New York. In California, usury protections against usury are embedded in the Constitution, and under both California law and New York law, usury does not apply unless the transaction is a loan. Right? If it's not a loan, there's no usury. So how do we characterize the agreement as a loan? Well, California law says that a loan of money is a receipt of cash now to be paid back in an equivalent amount over a period of time. Right? That's what it is. It's a very loose or broad definition. And interest is calculated as the cost for the use or forbearance of money. So in that sense, the discount that's given under the MCA agreements could be and should be construed as interest according to California code. And so the court is going to look at a variety of factors, mainly looking at where is risk truly allocated. The agreements are often contradictory. There's usually a clause that says this is not a loan, the parties agree that this is a sale. But then there's also a security agreement that gives the MCA lender a security interest in all of your assets, collateral, etc. Then there's a personal guarantee. If I breach it, if as the business owner, then I have to pay back this money absolutely. So then the question becomes, is there an absolute repayment obligation? When you get into the mechanics of the reconciliation, I find a couple of things. One is this reconciliation mechanism able to be applied? The answer is usually not. Why not? Because there's typically something in the contract that causes the borrower to default upon signing, right? There's some representation, something that the MCA can later say, oh, well, because this happened, we're not going to do that. You have to pay us back all the money. The next thing that I typically find in these deals is that there's something called the specified percentage. So these guys say, hey, well, we can't approximate what you're actually going to make. So we're going to say we get X percent of your receivables, and we're going to say that X percent means this dollar. Oftentimes, they're not based in reality. They're not based in the financials. They're just numbers pulled out of thin air. In some cases, I've seen the specified percentage is 50%, right? And so if the reconciliation mechanism is to determine whether or not the MCA is collecting more or less than 50% of your receivable, it's usually going to fail because they're not collecting 50% of your receivables. So you have these tensions within the contract that make these mechanisms meaningless. Meanwhile, these guys can shut down your business in 24 hours if you don't make a payment.
In your experience, what have you seen judges make of these type of situations where maybe the contract says one thing, the offer summary says something else, the actual transfer of funds doesn't match either? How do judges weigh in on this?
I've seen judges, it's a mixed bag. I would say that a lot of California state court judges inherently understand the inequitable nature of these transactions, but they're trying to figure out where do we go from a legal perspective. Because there's, like we talked about in a prior episode, there's a lot of choice of law and choice of form issues as it relates to these MCA agreements. In New York, I'm seeing a shift. New York used to be very robotic about, oh, well, it's got a reconciliation clause. There's no event of default. Oh, it's not allowed, right? But there's a secondary issue that's arising in New York. The courts are flooded with these cases, right? If these cases were truly about, fluctuating payments over time, then why, for instance, is one MCA lender that I've dealt with filed over 2,000 cases in New York in a 18-month period, right? That doesn't seem to make a lot of sense. So the courts are starting to go, wait a minute. What is going on here? From an administrative perspective, we're getting crushed a lot of these deals all deal with the MCAs. How do we get them out of our docket? And so now they're starting to look at the nature of the reconciliation clauses. They're looking at the volume of cases on their docket, and they're starting to reanalyze where things are going. And in the bankruptcy context, I would say that the judges are generally skeptical um, during cash collateral motions as to whether or not these are actually true sales. And I would also say that there's more and more cases in bankruptcy court across the country that are finding that these are more often than not loans. They're reasoning through a case called In Re Shoot the Moon, applying it to certain factors, and I'm starting to see more and more institutional pushback on the legality of these agreements.
Let's talk about usury laws for a second. How have you seen the courts kind of determine whether transactions violate state usury laws when the implied rate crosses the statutory caps? Even if the contract insists it's not a loan, right? How have you seen the courts kind of determine whether that transaction will violate the state's usury laws?
So it's a blend of law and fact. And a court is going to say, well, let's go back to California. In California, the court will look through the transaction to determine whether or not the transaction is a loan or something other that's dressed up that acts like a loan. And same with New York. And so they look at a variety of things that we've talked about, such as the allocation of risk, whether or not there's recourse against the buyer or the debtor in the event of a missed payment. And that is the key issue. And what are things that have the hallmark of a loan? Well, if I have a security agreement against all your assets, if I have a personal guarantee, if there's some sort of consequence upon a missed payment or whatever, these are things that the court will look at. Now, the challenge, though, and this is what I see a lot of attorneys make mistakes on, is they try to argue the law in many of these cases. And that's not always a good approach from a litigation perspective. You have to argue the facts, right? It's a blended question. So it's not only what does the contract say, how do the parties behave? And through that behavior, can we impute any legal significance on the transaction? For instance, I have a case where the contract said something like, "Oh, I'll only take a security interest in your accounts," which is reasonable on its face based on what this deal purports to be. But then, when there was an actual filing, they wanted to take a mortgage against the borrower's property. Well, we didn't grant you a mortgage in our property. That's not legal, right? So what are the behaviors that are being exhibited on top of what does the contract say? And that's what the court is going to look at to determine whether or not there's a violation of usury.
Let me ask you about cases you've handled. How have lenders' internal records, whether it be payout amounts, deposits, et cetera, like how has that contradicted maybe the contract's stated terms? And has it supported that finding of recharacterization? And explain to the audience what recharacterization is.
So recharacterization is, they say it's not a loan, but it's a loan, right? The internal records, I mean, I've seen all sorts of stuff, but some of my favorites include the contract is, let's say it's for $500,000, right? That's the total that needs to be paid out over the term. But when you get like the actual payoff quotes or other things from them, you'll see that it was actually coded in their accounting system as $800,000, meaning that they were knowingly going to charge more out of the get-go than the contract is worth. I've also seen them bake hidden fees everywhere in the contract. So you're paying far more money. And then a very common thing that they do is, let's say that if you miss a payment, and let's say they send out a 9406 letter or something like that. Well, they commonly say, oh, well, there's a default fee associated with that, which is usually like 40% of the contract. So like, again, putting that in real dollars, let's say it's $1 million purchase agreement. 40% of that's $400,000. So wait, they're going to get a $400,000 fee because I missed one payment, that's ridiculous. And so that's how you'll often find they're typically very reluctant on providing their records. And so oftentimes they're going to try to settle out before we get to that phase.
Stephen, as we wrap here, what are some specific provisions in these receivables agreements that tend to be treated by the courts as indicators that the transaction is a true sale or it's a disguised loan? What have you seen?
It's going to go towards, are the payments actually based on your receivables? Is there a proper allocation of risk such that the MCA lender actually retains risk? Whether there's a security agreement, what are the terms of the guarantee, and then what happens in a default? And if the record shows that under those factors that the purchaser retains none of the risk, none of the market risk, then they're going to treat it like a loan.
Yeah. Stephen, it's great stuff as always. Appreciate the time and the insights on this.
Thank you.
That's it for today's episode of Litigation and Capital with Stephen Mirsky. If you want to learn more, you want to connect with Stephen and the team, do me a favor, visit MirskyCorporateAdvisors.com right now. And one more favor, as always, hit like, hit subscribe, leave a review, comment, share it with someone who needs to hear it. I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.